Good afternoon, morning, whenever you are. It's still middle of summer, but as you can see out here in Southern California, there's still a lot of snow behind me. Um, so unusual, 100 degrees, but still some snow out here. Wanted to talk about a few things. One being the attorney's fee issue and what's going on in the hearings tomorrow regarding Tesla. Obviously, not legal advice. Please like, subscribe, share, comment, uh, proscribe if you want. Show your pets and animals. Tomorrow is a hearing date in the Delaware proceeding involving Elon Musk. Before I go into that quickly, I saw a headline today. It said two convicts evade noose, jury hung. Thought that was interesting. Um, I also saw someone said that they were married by a judge, but they wish they had been married by a jury or had asked for one. And last but not least, how many how many actual lawyer jokes are true? Only one, of course. The rest are completely true stories. Everybody knows that. So I wanted to talk a little about. So quickly, I'll move on. Again, this is just opinion. I'm not a lawyer based in Delaware, and it's a Saturday, so you have to take both of those into account. But I wanted to talk about what's going to happen in the hearings, the future hearings involving Elon's case, pay plan in Delaware. And I'm just kind of speculating here. Uh, Obviously, I'm a lawyer, have experience, but I don't have experience in Delaware courts nor with Judge McCormick. So it's all speculation to some degree. What's interesting a little bit about this case, so this is about the pay plan and the currently that pay plan was thrown out. There's an attorney's fee motion before the court. There's also a proceeding to undo the prior ruling through ratification. And just to follow it out, actually entered judgment for the defendant. So there's a request to, in essence, reverse the judgment, enter judgment against the defendant. So what makes this case different than I think most cases, and I know there was, I saw on Twitter or X, there were a bunch of people talking about other cases involving Tesla and attorney's fees. What I think makes this case different is that the amount of the attorney's fees is so large that this case really is only about attorney's fees. And kind of it maybe it was done intentionally or by error. The judge's only ability to impact the parties at this point in time is through attorney's fees, because the ruling rescinding the pay package, seemingly as it appears, could be renewed or ratified, and we shall see how that goes on, but it could be in effect, could be changed and undone. So as to the court's impact as to the pay package, in the grand scheme of things, it's limited. But in terms of the attorney's fee award, has some power, and that's how they can impact these proceedings. And that's why I think this case is different than all the rest, because it comes down to only attorney's fees, and that's really the only way that the court can exercise its power. And of course, in my opinion, this should have been a contract matter between parties and left as such. It should not be something that should be litigated. Obviously, I think that if Elon's pay package was negotiated and accepted by the board, that should have been sufficient, and we should move on. And perhaps in the future, Delaware will not handle things like this like they did before. Just on practical side, in my experience with judges, good or bad, they didn't change. So if I had an experience with a judge and they started off south, they usually didn't change their stripes. So if in fact the court changes its mind, and I'm referring to Judge McCormick, that would be unusual. and that would suggest something out of the ordinary has happened between the time of the proceedings and the time of her judgment. Now, some people might say that was the ratification itself, but that would be, I would think it would be something else, but I'm just purely speculating. It also may be the fact, I think Judge McCormick now has a big name, and a lot of times judges will go private. Either they will become a partner in some very large law firm, they will make a ton of money, they can make a ton of money, because with the name, they can draw a certain level of clients. Or alternatively, they can go do private judging, where they get paid, substantial fees for acting as a judge, but they have control over the schedule and control over what cases they want. And that's a way to go. So it may be the case that at some point in time in these proceedings or in the future, Judge McCormick's not on the bench. I'm kind of betting that at some point in time she will not be on the bench, and it won't be that far down the road. And that would be interesting to see who would take over and what the changes in policy might be in Delaware. So now we have the hearing that's set on July 8th. So presently there's a hearing for attorney's fees brought by plaintiff. So plaintiff is the party who brought the action. That's Toretto, the guy with the 4.5 shares. I'm being facetious, of course. I think he has 7. But that's the one who brought it, and his counsel is the one who's seeking the attorney's fees. And that's set for tomorrow, and there's been briefs filed by both sides, and the court has probably looked at all the papers by now. In some courts, as a matter of fact, in courts that I've been in, and I'm out here in California, before you would go into the hearing, you would get the judge's preliminary ruling. So you'd kind of know. And generally, this is kind of a truism, that if you get a preliminary ruling, the odds of being able to change that are very, very low. That means the judge and the court has gone through, made a decision, and no matter what you say, even if you stand on your head, it's tough to get them to change their mind. So I don't know in this particular matter, because all judges act differently and it could be different in a different case, whether there'll be a tentative ruling. It's called a tentative ruling. And if there is a tentative ruling, that will be available to both sides before the hearing. So they'll kind of know where the court stands, and you kind of look at it and you see what the points the judge is focusing on. And those are the kind of points you might direct your argument on. And in terms of if, in fact, that hearing goes forward on the 8th, they'll have both sides with an opportunity to present argument. Argument is just they'll present their position. Generally, the judges don't like to hear what's in your brief. There's no reason to repeat because somebody's read it. But there is a final brief. So somebody files the final brief, and nobody's responded to that. So in a hearing, often part of the discussion will be about replying to the reply brief. But there'll be discussion by both sides. The judge might ask questions. Eventually, the judge would stop oral argument. Now, the hearing date is July 8th. That's the hearing on the attorney's fees. But there have been other papers that were filed seeking to deal with the ratification, the vote that was on June 13th. And in fact, I think Tesla or the defendants, the individual defendants, there's a lot of parties involved. There's individual officer directors who are named. But those individual defendants, and I believe it was joined by Tesla also, have asked that the court enter judgment for the defendant, so to switch the judgment. So that doesn't have a hearing date, but in the correspondence I saw between the court that was public, it appeared that they wanted to set a hearing sometime in late July or in early August, sometime like that. I would expect, if they haven't agreed to a briefing schedule and a date, that at the July hearing, if nothing else, they'll agree upon a briefing schedule and a date for the hearing. So at the July 8th, will they go forward with the hearing? So what are the possibilities? They could just continue the hearing, so they could figure out a new date for the hearing on the ratification issue, and they could say, we're going to hear the attorney's fee motion on that same day. That's a way they could do it, and they could do it at the end. So if, depending on how the ratification motion went, that would determine whether you need to go forward with the attorney's fee motion. So that would be one way. And probably that's a way a lot of judges would move forward. An alternative way is the judge, and this would be a way of her demonstrating her power and authority, could go forward with the hearing on the attorney's fee motion. I believe it's been fully briefed to this point in time. In other words, all sides have submitted all briefs that were due, and the judge could hear it, and the judge could do one of two things. So that would be allow oral argument. One side would say, I'm entitled to $6 billion. The other side would say, you're entitled to nothing but $13 million, if at all. And I'm generalizing and shortening the argument, but that would be it. And the judge would limit the argument to some time period. And at the end of the hearing, the judge, if the judge went forward with the hearing, the judge could take the matter under submission, so could not rule at the time and hold it, and either make a decision prior to the hearing on the ratification, or could wait to the end after the ratification proceeding, or alternatively, the court could make a ruling. If in fact they've issued a tentative ruling already, then they could issue a ruling. And if that was the case, they would just generally, they would adopt their tentative ruling. But I don't know if they have a tentative ruling. And I would think in order for the court to show that they were not biased, that ruling on the attorney's fee motion prior to the ratification would be a bad move. And that would be a bad move because it might give the impression that you had prejudged the ratification issue. So I would think most likely that the attorney's fee motion will either be heard without a decision coming forward, either until later or until after the ratification, or it won't be heard at all and will be continued to the date of the hearing of the ratification proceeding. I think least likely of the scenarios would be a hearing and a result right away on the attorney's fee motion. I think it would open the judge up to criticism that I think would be appropriate, because it would not be timely, in my opinion, because that would be the end. Now, part of the motion that was brought by Tesla that hasn't been heard yet, and it's going to be interesting to see how the court decides about this, are using rules in Delaware. It's Rule 54 and Rule 59. And Rule 54 deals with reopening. Rule 59 deals with reopening. So you're in trial and you want to reopen to present additional evidence. And Rule 54 deals with basically changing the judgment based on new facts. And Tesla has thrown those out, and they use the ratification as the basis of the new facts. So it'll be interesting to see when it comes up in front of the court, whether the court sees the ratification as new facts on the existing proceeding or as new facts not related to the existing proceeding. And that would govern how I think she would make the ruling, if she's unbiased and is doing this in a strictly appropriate manner. So I know Tesla cited that. And again, ratifications are the new facts. So that's what they're claiming. They're claiming they're new facts, and that's why the judgment should be changed. And those new facts are the ratification that was done using a committee with full disclosure after seeing all the documents, with the burden of proof flipping and the business judgment rule now applying. That's basically the argument that Tesla made, and that the ratification caused that. So that's that. Then we're going to talk about quickly is fees and attorney's fees. So I saw the discussion about fees and attorney's fees. So technically speaking, sometimes attorney's fees can become costs in the pursuit of them. So I know that sounds kind of like nonsense, but it can happen. So by filing a motion or something like that, they might be treated as costs. But generally, fees and costs are different. So attorney's fees are one thing, and costs are like deposition transcripts, court reporters, filing fees, expert fees. It could also be, which is interesting, could also be like the committee. So Tesla, in doing the ratification, put together an expert committee, which I'm sure they had to pay for, and incurred a lot in costs. So I think that would be a cost. And so in you can have sometimes recover costs and fees. So I'm going to use California as an example. So in California, you can get attorney's fees if you have a contract that says attorney's fees. And we've all seen contracts sometimes that have attorney's fee provisions, and that be a basis. And sometimes statutes allow it also. So a statute might say that the prevailing party might get attorney's fees, or sometimes even there might be a statute kind of has different standards for who can get attorney's fees. For example, there's a statute here in California that that tries to discourage suits involved where someone's exercising their First Amendment rights. It's called a anti-SLAPP proceeding. And so you let's say you're on YouTube, you're making a YouTube video and you're expressing your opinion, and somebody doesn't like it and they sue you. Well, you're expressing your First Amendment right. So in California, there's a statute, for example, that gives you the right to challenge the suit at the very beginning because you're expressing your First Amendment right. And if you prevail on that motion, you get your attorney's fees and costs, and that could be substantial. If, however, the other side prevails, so they win the motion and the case isn't knocked out, they can only get their attorney's fees and costs if the motion was frivolous. So it's both sides could get it, but it might be different standards and different amounts. So again, difference between attorney's fees and costs. So here we have the attorney's fee motion that's going forward. And based upon if the court rules on it, that will be the ruling. If, however, the ratification is granted, so let's say the court enters judgment for Tesla, she finds, and per those rules, either Rule 54 or 59, she finds that there's new facts and that the judgment should be changed. It's not a final judgment until the attorney's fees are awarded, so it's not final yet. So she could enter a new judgment. If she entered the new judgment that was requested of Tesla and the defendants, then they would be the prevailing party. So what would they be entitled to? They could be entitled to fees and costs. They could be entitled, so that's legal fees. What would be the basis of the legal fees? Kind of the reverse of what plaintiff's counsel, I think, said. It's that common benefit. Perhaps the argument could be some kind of common benefit where they've saved Tesla and Tesla shareholders $6 billion because of not having to pay out the attorney's fees, which plaintiff's counsel asserts are reasonable. So that would be an interesting twist. But on top of that, even if they didn't get such a significant number, they might be entitled to recover their costs. And their costs here could be in the millions. Just the committee alone could be in millions of dollars. So that's why the ruling on the ratification is immensely important. And it will be interesting to see if the court doesn't rule, doesn't have a hearing, and what that end result is. Again, like I said, I don't expect judges to change their stripes, so it'd be interesting if this one did. But I also believe that if this thing goes up and the result is even more ridiculous than it is now, in my opinion, then it's likely to be overturned at some level at some point in time. And obviously, if Elon's not paid per his package, he has a right to go get paid. So he has a right, if the contract gets thrown out, I know it hasn't been discussed a lot, but if his contract gets thrown out, so he's not getting paid, he has a right to get paid for the reasonable value of his services. He would have seemingly a right of action against Tesla to get the reasonable value of his services. Maybe that litigation could be resolved in a friendly manner, perhaps, to everybody's satisfaction. But obviously, he has a claim under quantum merit for the reasonable value of his services. In the proceedings, we're talking about attorney's fees. One of the ways that attorney's fees are measured is that same way, quantum merit. If you don't have a contract, basically says if you don't have a contract that can be specifically produce the numbers, but you did provide services of value, then you can still recover the reasonable value of services, even if you don't have a contract that absolutely is on point. So that is whatever that is. Now, last but not least, I think all this is going to go up on appeal one way or the other. If it goes Tesla's way and Elon's way, then the plaintiffs will appeal. More plaintiffs' attorneys will appeal. And I don't think that's meaningful, by the way. So I wouldn't get upset if they appeal, is the point. I think it's just in the cards. These guys, I had an experience. I was working in Las Vegas with a real estate development company in 1988. At one point in time, we were on this project. We got these appraisals sent to us. I had an equity interest. For one day, I was worth a very large number. That disappeared. I was not as happy the next day when it disappeared. So here we have a bunch of plaintiffs and lawyers who happen to find somebody with a apparent sympathetic ear who were thinking when they were parting after the result they got that they were going to get billions, who might get, still probably too much, but will get likely a significantly lesser sum. So why wouldn't they appeal? So I expect them to appeal, and that's kind of what just to be expected. So I expect one party or another to appeal. And what you have to remember about an appeal, which makes it kind of different than the underlying trial, is that the facts are decided. So when you take them up on appeal, it's a legal question. So, for example, a court of appeal, and I'm sure Tesla would argue and Elon would argue the standard of proof that was applied was the incorrect legal standard. I'm giving you just one out of, I'm sure, many grounds. And that's a legal question, not that the judge made a factual, that her decision on who to believe was incorrect. So when you have an appeal, and there are obviously exceptions to everything, everything we say. But if there's an appeal, the appellate court just takes the factual record from the trial court and then looks for the legal errors and then has to find the legal errors to be not just they occur, but to have been impactful for the case. So that's kind of where I see it. So have a hearing tomorrow. It either will be continued, or be heard. A decision will either be granted or it'll be held under submission. Likely, if it's held under submission, likely till after the ratification hearings are held, depending on the outcome of the ratifications. And if the judgment is entered for Tesla, then that would change future proceedings. Again, I have my experience is that judges don't change their stripes often, so I keep that in the back of my mind. And if there are appeals, that does not influence me or make me concerned one way or the other. Again, I think this is a case about attorney's fees, and that's what drives it. And that's where we're at. And that happens to be exactly where we are in the proceedings. And again, I think it's different than all the other cases that are pending because of that, because of the amount of the attorney's fees, and because that's the really only benefit that exists here. Because even if the court was successful in undoing the pay package, seemingly the next day that pay package could be imparted, and it's not even been discussed. I don't think I've seen it discussed in the papers. Elon's going to get a pay package theoretically, perhaps even the quantum merit pay package could be even larger than the pay package he received. That's possible. And then what would the benefit be? I don't think it's been discussed because we haven't quite got to that point, but that's kind of the point we're at. So that's a quick summary. After I see the results, I will let everybody know to the extent I can figure it out. And that's it. And just one last point. So there are times when attorney's fees can be awarded besides contract and statute if actions are frivolous. There are certain rules that can provide attorney's fees. For example, in California, 128.6, 128.7, Rule 11 in federal, but it has to be a frivolous action, completely frivolous. What's confusing about this one is the court already ruled on the primary issue, put that in quotes, for plaintiffs. So I think it would be hard to find, even though I think it's a frivolous lawsuit brought solely for the benefit of plaintiffs' counsel, just my opinion. But because the court already found that way, it would be hard, I think, for it now to find it frivolous because it would be under kind of attacking its own ruling in a way. I just don't think it would go that way. But again, the bottom line is I don't think the court should be in this sphere. This is a contract issue, should be allowed, freedom of contract should be allowed, and that's it. So hope that was helpful. Hope that wasn't any more confusing. If you have any questions, comments, please put them out there. If I could respond, I will do so. If I could respond in a coherent manner. If you disagree, please state your disagreement. I'm pretty skeptical and very conservative about my opinions about judges, so I'm wait and see. That's how I go. But I think it's an interesting tactic, interesting strategy, a really aggressive attack by Tesla. That's puts a lot of pressure on everybody, including the other side. And we will see. Everybody, have a great weekend. Stay cool wherever you are, and be well.